So no matter what collaboration you have with China, you're likely to encounter some cross-cultural challenges and issues. At Crayfish, we have developed a model to address all those in a systematic way, and our webinars are designed to spread the knowledge and best practices to help you to overcome those challenges. You can check out the forthcoming webinars on our website page. We have 3 for the rest of March, typically on a Tuesday. So today's webinars is on IP protection, and particularly talking about patent infringement litigation in China. So ever since I started advising Western organizations to do business in China about 17 years ago, IP has always been a top concern for IP owners. I've seen many businesses got their IP ripped off and product counterfeited, but this is not, of course, unique to problems in China. In the meantime, I've also seen clients successfully licensing the IP and monetize the IP in China. Indeed, do very well in a business, despite of the problem they had in IP. What made the difference lies in preparation to develop a good IP strategy and protection, but also when things do go wrong, to take a systematic approach to protect your IP. That's why today we have invited 2 experienced China IP law specialists from our partner IP law firm Kangxin, based in China, to speak about these important matters. And this is actually the second session of the IP series. We already had one last session a few weeks ago, emphasizing and explaining details how to protect your trademark in China. And if that's an area you're interested, you can go to our web page to see the recording from previous session. So now I would like to introduce the first speaker, Nell Greenhouse. Nell is a bilingual legal consultant and case manager specializing in IP strategy and consultancy. She speaks fluent Mandarin, by the way, and she advises both overseas and domestic clients, ranging from Fortune 500 companies to high-tech SMEs. She was born in England, but she has worked in China for many years and have a great understanding of Chinese business landscape and culture. So now over to you now.
Hi, Ting, can you hear me?
Yes, oh, very good.
Perfect. Thank you very much for having me back. It's an honor to be back here in the next on our series on IP in China. So last time I was here, we established IP in China. It does exist, useful. And we also went through some more important aspects of Chinese trademark law, as well as the current trends of Chinese IP law. So today we're going to turn our attention to focus more on patent law here in China. So I'm going to be focusing more on enforcement measures. Okay, so I'll take you through the enforcement measures, talk about the pros and cons, and then my colleague Ewan will talk us through how to go about patent infringement litigation and introduce some important cases in Chinese IP law. And although these do have more of a slant towards patent law, they are also applicable to other rights, so other IP rights. So you can use many of these enforcement measures for trademark rights and also for copyright. Okay, before we start, I just want to say that before you go about enforcing your IP, the most important thing you can do to enforce your IP and to prevent against infringement is to have a rights basis. Okay, you must have a rights basis before you can take any of these measures. So what does that mean? You have to make sure you have rights registered in China. Okay. So your trademark rights, patent rights, copyright, they all should have a basis within China. So for example, if that's trademark, that means ensuring that your company name is registered, and not just your company name, your product names and your services, as well as your logo. Okay, so today I'm going to talk about enforcement measures, and the three measures I'm going to speak about broadly fit into the following categories. Okay, so first we have ADR, alternate dispute resolution methods. Okay, these tend to be significantly less formal methods to deal with infringement. Okay, one of the benefits of them is they tend to be more efficient, a quick way of dealing with infringement, and they tend to be low cost. Okay, so they're fairly inventive, they're fairly effective, and they can also be a really good way to prepare for further action. Okay, the second form of enforcement measure we're going to talk about is in administrative actions, which you can take. So bringing an action before a local IP bureau. And this is faster than litigation and also has its own benefits, which I'll talk about further later. Finally, we have litigation, okay? And so I'll discuss what are the benefits of bringing a case for infringement to court. Okay, could you help me move on to the next slide, please? Ting? Thank you. Okay, so first, this fits into our first category of alternative remedies. So the cease and desist letter, this is the bread and butter of IP lawyers. It doesn't matter what your IP right is. In most cases, you can and should use a cease and desist letter because they're very cost efficient and they can be effective in stopping infringement fairly swiftly. They can also be used as good evidence in further legal action. And on top of that, they can also be useful in terms of proving the bad faith of an infringer. Okay, so for example, where in some cases infringers may in court in later litigation say that actually the goods that they purchased were purchased at a reasonable price and therefore they constitute a legitimate resource. Okay, so where we've sent a cease and desist letter, this defense cannot stand. Okay, next slide, please. Ting, can we move to the next slide? Customs recordal. Okay, fab. So a customs recordal, this is something you should do the moment that you have your rights established. From the outset, I should say, these are much more effective in trademark cases than in patent cases. Because what they do is the local customs can prevent products being imported or exported if they're suspected of being infringing. So obviously that's difficult to determine in the case of something like an invention patent, okay? But with trademarks, because you open up the crates, you see, okay, it has the trademark, it's fairly easy to establish. And if it is established, these goods will be seized and they can be destroyed. Now, there are cases in which infringing patent products have been seized and are seized, but generally speaking, in these cases, customs will not proactively search for infringing patent products. Instead, what they will tend to do is they will be notified by you or by your lawyer to say, I have information that a shipment is going to be made in the following days, and this specific information will lead to the products being seized. Okay, so this can be a fairly important way of dealing with infringement and fairly easy to do. Okay, let's move on to the next slide, which is making a complaint before a sales platform. Okay, this is a very interesting way of dealing with infringement, mainly because it can be so efficient. Okay, it's very fast, it doesn't take particularly much time, and And of course, you can only require them to stop infringement. You can't get compensation. But the majority of sales platforms these days have their own dedicated IP teams, as we discussed in the last seminar. And this means that they are committed to dealing with infringement. And recently, in 2019, there was a new e-commerce law, which demonstrated that sales platforms may be held liable or will be held liable where they fail to act. I think Ewan will take us a little bit further into this later, but with the development of this law and various case law into sales platform infringements, this is going to be a more and more important tool that we can use to combat infringement. And especially where an infringer sells only online. This can be really potent in dealing with the infringement because suddenly they are unable to profit from their infringing behavior. Okay, next slide, please. Okay, so this is the final aspect of our ADR, so our alternate methods of dealing with infringement, the exhibition complaint. Okay, so this is where you know that an exhibition is taking place and that potentially infringing goods are being sold. You can make a complaint directly to the exhibition holder. And it's down to their discretion whether they accept your complaint and what methods that they do take to combat it. But it can be a very quick and effective short-term measure in dealing with infringement in these cases. And not only that, but long-term, because it takes place in such a public space, it can cause great reputational damage to infringing companies because it's in front of, especially where they're B2B, it's in front of a lot of their potential customers, and you can increase pressure on infringers by dealing with media. Okay, so you can write some PR or you can invite journalists to come and cover the event. Okay, there is no compensation in this in this regard. However, yeah, there is also no enforcement either. So these things, it's quite difficult to gain any deeper benefit other than sort of the short-term measures of the exhibition and reputational damage. But it can be a very good method to deal with those too. Okay, next we're going to go on to administrative measures that we can take. Can we move to the next slide, please? Okay, so this is the complaint before the local IP bureau. So this is an interesting option to take. It is significantly quicker than bringing a case before the court. Okay, so only 3 to 4 months. And what the key here is that they can obtain an administrative decision. Okay, so this means they can come to a decision as to whether infringement has occurred, okay? But there are no further powers to seize the goods, to destroy the goods, or to seal the goods, okay? You can only stop them. You can only require them to stop the infringement. And they don't necessarily have the powers to deal with the root source there, okay? There are enforcement measures available, and so if an infringer is not complying with the decision made, you can bring an enforcement action before the court. Generally speaking, though, our clients don't choose to do that. The reason why they would choose to complain before a local IP bureau predominantly is to collect extra evidence, okay? So the IP Bureau can take copies of account books, they can take copies of contracts, and these can be incredibly useful for further action where you need to prove the defendants their profits, the infringer's profits, or you need to prove our losses, our clients' losses. Not only that, but the evidence that is sourced by the IP Bureau can can be constituted as fixed evidence. So you can bring that before the court without the need for notarization, which we've talked about before. Okay, finally, moving on to litigation. Tim, can you move us on? Thank you. Okay, so a complaint before the court. So this is a fairly lengthy process, okay, 8 to 15 months, and then it may be appeals. But you have a team of professionals dealing with your case and making a judgment on whether infringement has occurred. You can obtain compensation. So although this is expensive, court fees are expensive, but you can claim compensation, including reasonable costs expenditure. So you can claim for your legal fees, you can claim for the court fees. Now, at the moment, compensation, statutory compensation, is capped at 1 million RMB. But in the draft patent law, that has been increased to 5 million RMB. So hopefully that will be the case by the end of the year, with the lower limit for statutory damages being increased to 100,000 RMB, which is tenfold from what it currently is. Okay, and not only that, but actually within the draft patent law, they have included punitive damages, okay? So where infringement is considered to be willful and where it is considered to be a severe violation of the patent law, then they can claim punitive damages of 1 to 5 times either the profits of the infringer or the losses of the client. And actually, you know, as this hasn't become law yet, we don't know how you can quite fulfill those, but it will be really interesting to see how that develops over time. Okay, so I've run us through the various different enforcement measures available, and I'm going to hand back to Ting to introduce my wonderful colleague, Yuan. Thank you very much.
Thank you, Nell. That's very, very helpful. By the way, I forgot to mention that Nell also has been... Yes, hello.
Can you hear me?
Can you hear us? Yes. Can you hear us all right now? Yes, I've just saying that Nell previously also appeared on as a panelist on the Chinese very popular political talk show Tiger Talks. So now I would like to introduce Ivan Li. Ivan is an attorney at law, a patent agent, and previously worked as a pre-patent examiner in China's IP office. He has over 8 years experience working in an IP law area and also handled over about 800 IP cases in the legal field in China. So he has experience working with clients from all over the world. So here, over to you, Ivan. I hope you can hear us.
Oh, thank you, Ting, for the introduction. And thank you, Nell, about the great presentation and the clear introduction about the legal actions. But before taking those legal actions, what kind of preparation we shall conduct? And in this slide, we will talk about where to start. So the first thing is about the patent right. About patent right, we certainly need to prepare some documents, such as copy of patent register to prove the state of the right and the patent scope. But this is not what we talk about today. Today, we talk about the most important thing during the preparation of patent right, which is the evaluation of the stability of patent. Okay, there are 3 types of patent in China: invention patent, utility model, and a design patent. So if the client's patent is an invention patent, generally speaking, it went through the substantial examination before it was granted, which means that we could assess the right is stable. So we don't need to do the retrial work before, or we can do some necessary trial work to confirm it. But if it is a utility model or a design patent, so it might be unstable because they were never through the substantial examination, which means that it is necessary to conduct a private art retrieval and screening. And secondly, if it is a utility model or design patent, we suggest filing an application before the CIPO. CIPO is the patent office in China about an official report of patent evaluation. And this report is not only to evaluate the stable of patent, but also to a certain extent, it can avoid the suspension of the litigation. Once we file a patent infringement lawsuit based on the utility model or design patent in China, one common defense of the opposite party is to file an invalidation against our right. And some countries, maybe most countries in the world, the patent invalidation procedure will be directly proceeded in the court. But in China, it is different. The invalidation procedure will be proceeded before the patent office, which means that the court may or may not suspend the ongoing patent infringement litigation. So considering the stability issue of the utility model and design patent, if there is no such official report, it is very likely that the court may suspend the litigation, which we would rather not see. But if there is an official report, it can effectively reduce such risk. So that is what we want to emphasize when preparing the patent right. 1, necessary prior art retrieval, and 2, official report of patent evaluation. So the second thing we want to talk about is collection of evidence. So the keyword here is necessity. As Neil mentioned, it is very difficult to collect the evidence in the IP disputes, even the most common consumer goods. Some clients may think that we can just purchase one in the supermarket, then the sales behavior will be fixed. But that might be not enough. You don't want to only sue the seller, right? So if you want to address the issue for good, you need to confirm the actual manufacturer, which may need more in-depth investigation. And not only that, the most difficult part to collect the evidence is always about the compensation evidence collection. For example, the accountable, which can prove the profit of the infringer, is always in hands of the infringer and the difficulty to obtain. So sometimes, for supporting our large amount of compensation claimed before the court, you may need to do some on-site investigations against their factory so as to dig out more information, such as scale of the factory, the inventory of the infringing products, or the production capacity. And once we take actions, which Neil mentioned, the opposite party will be alertness, and which make the evidence collection more difficult. So I have to say, the successful evidence collection is our first step towards success. So the second thing I wanted to emphasize is about how to fix a solid evidence. So the most popular way in China is to collect evidence under the witness of notary public. The notarization system in the evidence collection in China is very common. Maybe in America or some Western countries, they have a sound honor-based system. For example, the witness will give testimony under oath. But there is no such system in China. And considering the difficulty in evidence collection in China, we may need the credibility of notary office to obtain a solid evidence. So the third part I wanted to discuss is infringement analysis. And in this part, we are talking about the patent infringement comparison. I have to say, many defendants will conduct the non-infringement defense during the litigation, and it is very important to evaluate the possibility of the infringement before. So it seems easy to do that, right? You just need to compare your product, the opposite party's product and your patent. But how to understand the scope of the patent if there is a vague scope? And how to determine the infringement if there are slight difference between the product and the patent? Some doctrines will be introduced to determine the infringement, such as the doctrine of equivalence and doctrine of complete coverage. And I have to say that an accurate grasp of all kinds of doctrines is very important during the comparison and need a solid legal foundations and rich practice experience. And of course, you also need to prepare some other materials, such as the documents to prove the client's identity, the documents to prove the client's attorney relationship, like the power of attorney. And when we prepare all those documents, it's time to take actions against the infringers. So the next topic we will talk about is two representative cases. It is all about the infringement lawsuit, but both cases are involved some other actions introduced before. So I hope these cases can bring you some inspirations. So the first case is about a patent infringement lawsuit. The right basis is a utility model. It belongs to an individual whose name is Sun Junyi. So the plaintiff is the patentee, Sun Junyi, and the defendant is the salesperson, Zheng Ning. And firstly, in the next slide, I will just give a very brief introduction of the whole procedure. Team next, please. Thank you. And in 2013, a boiler factory sent a notification letter to Zheng to warn his infringement fact. And the fact owner is Sun Junyi, which is the patentee of that right basis. And in this letter, this warning letter, there's a basic information of the patent offered, and there is a company seal of boiler factory and signature of Zheng. And on July, after the patentee sent this warning letter, he purchased a product and sued Zheng. And during the hearing, Zheng made a defense of legitimate resource. So here is what is the defense of legitimate resource. It means that if a salesperson can prove that the product purchased is from a legal resource and do not sell the infringing product intentionally, which means that there is no intentional infringement, he will exempt from paying for the compensation. And then it went back and forward between the different courts. And finally, the Supreme Court just appointed the Superior Court to retry the case. So after this retrial decision, there is no further judgment or ruling online, which implies that they may have a private settlement or something else. So here is the question. Why the Supreme Court withdraws the Superior Court decision? So the best part is here. The best part in this case is the judgment of the Supreme Court. And in this slide, we will talk about the major dispute and the retrial judgment. And it is very clear that the main dispute is whether defense of legitimate resource of Zheng can be established and whether Zheng can be excused from the compensation liability. And I have to say, in the judgment, it gives a very clear requirement for the warning letter, also the cease and desist letter. So the patent information, the infringing products information, such as the accurate product model, and at least the comparison result shall be described in this letter. And if this letter is too vague, unclear for the infringer to understand, it may not compete with the legitimate resource defense. And the establishment of this defense is to sustain the marketing order and encourage the penalty to crack down on the infringement from the source. And one of the preconditions is to prove that there is no intentional infringement. But generally, it is very, very difficult to prove that the infringer has an intentional fault. Thus, the warning letter is a way to solve this issue. And in this case, once all basic elements were described in the letter, it shall be determined that the infringer already knew of the infringement. So this case, I have to say, is one of the representative case which provides a very standard to prove the intentional fault. So we can move to the next slide. This is about another case. This is not a patent infringement case, but a trademark infringement case, which is also a very common type of IP dispute. And in this case, the right basis is a trademark Tinivini of the Eland Limited. And this company is a very famous Korean garment company. And Tim, maybe we can move back to the last one. Thank you. So the plaintiff is Elian Garments Trading Company, and it is the exclusive licensee of the trademark Tinivini and also a subsidiary of Eland. And he sued Zhejiang Taobao Network Company and Du Guofa. Taobao is a very famous e-commerce platform in China, very big. And Du Guofa is the infringer. So in the next slide, we will introduce the brief timeline. So Eland, since 2006, Eland complained before Taobao over 10,000 times for all kinds of infringers on Taobao. And in 2009, he noticed that the infringement of Du Guofa on Taobao platform. So since September, Eland sent notification letters to warn Taobao. And every time after Taobao deleted the website, Du Guofa just puts the infringing product website again online again. So Eland's Chinese company sued Taobao and Du Guofa before Pudong Court. So in the first instance, Du Guofa and Taobao were determined to constitute a joint infringement, and Taobao challenged the judgment and appealed to Shanghai First Intermediate People Court. And during the second instance, the court dismissed the appeal and upheld the judgment on April 2011. And we can, thank you, Tim. And the first instance and the second instance of this case, the main dispute is the same. Whether Taobao should know Du Guofa's trademark infringement, and whether the reasonable and necessary measures were taken by Taobao, and whether Taobao shall be taking liability. Apparently, in this judgment, although Taobao deleted in the infringing website every time, but it did not take effective measures to stop the infringement. So it had to bear a joint liability with the infringer. Actually, it is high demand to the e-commerce platform. You cannot just deal with the tort passively. You shall do it positively when you know of the infringement for sure. In fact, many world-famous e-commerce platforms already realize that trend. For example, Amazon. In its latest annual report of Amazon, it has warned investors, and it is the first time being reported in its annual report about the risk of counterfeits on its online platform. And the warning comes because it was forced, Amazon was forced to defend itself against the criticism that it is complicit with counterfeits. And according to the latest news last week, Amazon will establish a system called Project Zero. I think it's a really cool name, to fight the trademark infringement. And I think it is really worth to look forward to. And I believe more and more e-commerce platforms treated it very seriously. And same things happened in China. On January 1st, 2019, Chinese electronic commerce law, we just call it e-commerce law, it is carried out. It defines the liability of e-commerce platform operator. After the e-commerce platform was notified, the e-commerce platform operator has to promptly take necessary measures. If they did not, the e-commerce platform operator and the infringer shall be jointly liable for the subsequent damage to the IP right owner. I believe the actions of complaining before the sales platform will become more effectiveness and everything will get better. And that's all we need to talk about today. And thanks for Neil and Tim, and thanks for all your listening. And we look forward for your questions.
Thank you, Ivan. Very interesting cases indeed. I hope everyone has found the presentation helpful. Before we take questions, I'll just quickly tell you a bit more about how Crayfish can help you with your business in China, along with our partners. In addition to the self-service marketplace, we also offer tailored services for more complex projects under Crayfish Enterprise. The areas we help cover all aspects of the business in China, from market entry to IP protection, from translation to marketing, and also from HR to sourcing, etc. Specifically on IP protection, we work closely in partnership with Kangshin, with Neil and colleagues there, and we have already helped many British clients with their trademark as well as IP registration. For any other questions later, you could always reach us at our emails here. So with that, shall we start the questions? We have a questions coming through. It's regarding software copyright. It says, how do you enforce software copyright protection in China? Is that the same way as a patent?
Sorry, could you just repeat the question again? We dropped the line a second there.
It says, how do you enforce software copyright protection? Is it in the same way as in other forms of patents?
The actions are similar, and but the right is a little bit different. But we could take the totally same actions and to defend against those kind of software infringer.
Okay.
Okay, thanks. Can you go to the next question?
Next one. What documents are required to file a patent infringement action in China?
You mean all the documents? We need a complaint, we need the evidence list, and we need to prepare the basic evidence to prove the infringement. And about the composition evidence, we don't need to submit it when filing the complaint before the court, because it is not a necessary evidence. But we can submit it during the adducing evidence period or maybe during the hearing. And also we need to submit some materials to prove our good standing of the company, like certificate of incorporate and certificate of legal representative identity. And please, all those documents like the power of attorney, certificate of incorporate, and certificate of legal representative identity has to be notarized and legalized in your country. And those documents, after the notarization and legalization procedure, will be the effective documents used before the court.
Okay, thank you.
Cool. There are more questions coming in. The next one is why customer recorder method is not effective in cases for patent infringement.
Sorry, why was a customer, sorry, is it recorder? Okay.
Recorder method is not effective in cases for patent infringement.
There's two aspects. First, the customer generally will not do it actively, so it have to based on your application. So first, you have to know the exact number of the cargo, and you have to know the exact time of import or export. So you have to know all those informations, and you give this information to the customer, and then they would like to do those customer disposal. Yeah. But if the trademark, they may do it actively. Yeah. So it will be more effective way to solve the trademark issue. And the second thing is that if it's a design patent, it will be easy to determine whether there is infringement. But if it's an invention patent, the customer generally will not do the determination. They may just seize the goods and to require you to file before the court. And if you don't file the complaint before the court in a certain days, and they will just relieve all the goods.
Yeah, and just to clarify, when it comes to customs recordals, actually, when they are proactively checking, so we've said it's difficult to determine if infringement has occurred, but when they're proactively checking, what that means is that 1 out of every how many shipments will be randomly checked. Okay, so it's definitely not every single shipment is being checked. What it means is that it's difficult to say for each customs, and we don't have figures as to how many they check or what percentage they do check that comes through. But yeah, it will be a random percentage.
Cool. Next question. You say the patent office decides validity. Are they more pro-patentee than the courts? Also, do they interpret the claims in the same way?
Can you say that again?
You just said the patent office decides validity. Are they more are they more support patentee than the courts? Also, do they interpret the claims in the same way?
So just to clarify, you're asking if they're more pro-patentee? Sorry,
Yeah.
I think I still not got this.
Yeah.
Can you go one more time?
I'm just sending it across to you.
Okay.
Just give me one. Yep. Did you receive it?
No, not yet. Oh yes. Okay. Okay. So the patent office decides validity. Are they more pro-patentee than the courts? What are your thoughts on this? So are they more supportive of patentees than the courts are?
I don't have those data at present, but I think that if you failed in the invalidation procedure and you file administrative legal litigation against that decision, I have to say the win rate is not very good. The win rate is like 10% at present. I don't know whether you ask about that.
Okay. Oh, we've just had the next question popping up for us.
Yeah, so next question and the last question. Do you think UK and China can have a trade deal soon so the IP rules can be unified from 2 sides?
Well, that's an interesting question. I'm not sure I'm the right person to ask that. Yeah, that's a really, really, really difficult one. Hopefully, yes, that would be great. I think we'd all be much happier if that was the case.
Okay, right. Thank you, Nell. So thank you for everyone who's been listening to the webinar. I hope everyone has found all this interesting. Both Nell and Eva mentioned the retail platforms in China, which involves a lot of digital marketing, of course. So if this is an area you are interested, our next Tuesday webinar deals with China's digital marketing landscape. And then the following week, Tuesday, it will be about selling to China. So we'll see you there. And then, thank you, everyone. Goodbye. Thank you, Nell and Evan. Goodbye.
Thank you.
Thank you.